We're going to call to order
Oh, it's in here. What's the one you got?
the contested case, reopen the contested case hearing. It is 5:20 on April 7th, 2011. Can you call the roll, please?
Mark Key.
Here.
Jimmy Skipson.
Here.
Wayne Jernigan. Here. Ray Denson. Here.
All right, we'll go to open up the hearing. Open the hearing back up. Item A, board to hear contested case submittals concerning board approved permit for Wimberley Springs LTD. And the attorney, Almond, is not going to be with us, but we have Marissa.
Correct. Mr. Allman, as you probably are aware, is unable to attend today, so I'm here. I'm with the same firm. I'm Marisa Fedales, and I'm with Larry Frederick Fedales, Allman, and Rockwell.
All right. We're going to give you 10 minutes for any oral arguments.
Okay.
And then the other attorney, 10 minutes. And if we have any questions, we'll ask you questions and go from there.
Okay.
Step up here.
Good afternoon, and thanks again for waiting for me, and
Sure.
I apologize for being a bit tardy. My understanding of the issues presented for you guys today, and I won't go through all of the specific facts in support of the various hearing requesters, as you've got all of those in front of you, but my understanding of the issues that are presented before you today is whether there was a concrete, hard and fast deadline for submitting these hearing requests. And so I'll focus my comments on that issue. And although I've not been on this case for very long now, my reading of the rule, I went through the rules, and my reading of the rules, I found no hard and fast deadline for hearing requesters to submit their hearing requests. And accordingly, this board has wide discretion in determining how and when folks can submit their hearing requests. And in particular, when you have hearing requesters, as we have here today, such as Ms. Smith, who has property rights, and when we're looking at an opportunity for property owners such as Ms. Smith to protect those property rights, it's incumbent that any notice that's provided regarding that opportunity is clear, unequivocal, and sets forth any deadline that will cut off her opportunity to protect those property rights. As I understand it, that type of notice was not provided, giving her clear, or giving other property owners clear and express deadlines as to, or even instructions as to how to participate in a hearing that would help them protect those property rights. In light of that situation, I encourage the board members to, on their own motion, exercise their discretion and look at the facts, look at the statements that have been presented in the various hearing requests, and determine whether any of these satisfies the requirements for participation in one of these hearings. And if they satisfy those requirements, if it appears that they do have property rights that will be affected by the applications at issue in this case, then the board can use its discretion and on its own motion admit those property owners as parties to this proceeding. And finally, one last thing I'd like to mention is that in reviewing the rules, I also did not see any specific instructions as to exactly how those hearing requests should be submitted. So for instance, I saw no prohibition on submitting hearing requests via email, nor did I see any prohibition on submitting hearing requests via email after 5 o'clock. Nowadays, where we have e-filing, even in district courts and courts of appeals, it's easy to verify what particular date any document is received by that tribunal. So for instance, in district court, you e-file your document, you can do so up until midnight, because with email, it's easy to verify that you submitted it on the date that it's due. And so I, again, encourage the board to follow those kind of e-filing guidelines in this case and look at the date that people have submitted their hearing requests. And so long as it arrived by the deadline, by a reasonable date, a reasonable time, I again encourage the board to consider those hearing requests and allow them to participate in any hearing to protect their property interests. Thank you.
All right. I have a question for you on that.
Sure.
One of them, you'll state it came in at 5:12 p.m. And you're saying that we shouldn't, it should just be just whenever?
Well, it's certainly
I mean,
up to your discretion as to what you would consider a reasonably filed or reasonably timely filed hearing request. And the way you can do that is either by, if you interpret your rules in such a way as that any hearing request must be received by 5 o'clock, then you can grant a short extension of that deadline. On the other hand, I didn't see anything that said 5 o'clock on this date is the hard and fast deadline. In that case, if it's in by the date that you requested before midnight, then it should be deemed timely filed. That's how we do it in district courts now, and that's how we do it in courts of appeals.
In district court, if you got it in at 12:15, would it,
If we got it in at 11:59 p.m. on the day.
before
that it
midnight,
was-
right?
Right.
But if you got it in at 12:01, what would happen?
It would be the following day, and then you'd have to either get an extension of time approved.
What was the reason for it? That was on, you didn't, nowhere did y'all state the reason?
I don't know, and I simply, I wasn't the one who drafted or
No.
filed that.
Okay, then there's you had a pleading, but no one says, normally in a pleading, I think you say we had a flat tire. Today you're here because the man
Right.
in the hospital or with his wife,
Right,
that seems logical that we gave you time,
right,
waiting for you since he's in the hospital.
right.
But what was the case on this one?
I don't know.
Could you, I'm gonna have
I
other
could find
people
out.
come up, you could find out.
Sure.
I saw the pleading, but I didn't see where it said, gave any kind of a, if the reason was, we thought we wanted, I don't know.
Okay, I'll try to find out before the end of today's meeting, and if I can't, I can certainly submit something in writing first thing tomorrow.
I believe today will most likely be some decisions made tonight.
Okay, then I'll try to find out.
All right. All
Are
right.
there any other questions I can try to answer?
Anybody else have any questions? We still may ask you something here in a minute, but right now I think we'll give you some time to listen to what he says, and we'll go from there.
Okay, thank you.
You have a question? Oh, wait, I'm sorry. Jack, go ahead.
Mr. Chairman, I can explain from one point of view. I was the one that submitted that letter that went in at 5:12, and I can give you some particulars on that. I was working at the library. I don't have a computer at home, so I was working to send this submission at the public library here. And when you sign up there, you get an hour. And I've been working, and my hour was up at about 4:30. And I suddenly realized they kicked me off before I sent it. I had everything just ready to go. And I tried to log back on, and the system says you gotta wait 30 minutes. So I waited a little while, and I thought, yeah, I'm gonna be late. And I went to the librarians and talked to them, and finally got back on the computer, but by then it was after 5 o'clock. And so it was 5:12 when I actually sent it. That's my story.
Yes, sir.
Thank you, Mr. Chairman. My name is Russell Johnson. I'm here on behalf of the applicant. And I want to start by saying that the premise of the argument that you just heard is that there's no hard and fast deadline in your rules for making a request for a contested case here and filing a protest. And I'm here to disagree completely with that statement, because Rule 3 of your rules lays out a process for deciding applications for permits. It It's a very straightforward process. The first step is administrative review by your staff and determination that the application is complete. The next step is basically a recommendation from the staff, a permit recommendation that then basically requires publication of notice, setting of a hearing, and consideration of oral, written, and formal protests at the date of the hearing. The most important part of that rule, if you look at 3.2, basically it lays out a process by which these applications are to be considered. You'll notice that first there's the determination of administrative completeness, then there's the operating permit notice requirements, which the record will reflect were all complied with in this case. The intent there is to not only provide individual notice to landowners who are adjacent and within a quarter of a mile, but to provide general public notice of the hearing. Reflecting the district's proposed action, there's a hearing requirement, and notice in the hearing requirements section on page 3 of Rule 3, the board shall schedule a hearing which will be held at a regular board meeting where the board shall consider the application and any evidence presented at the hearing. Any interested person may provide oral or written testimony at the hearing or may file a formal protest against the proposed action. There is the deadline. Because the next sentence is, following the hearing, the board may, and it lists your options. Now, much has been made, and I didn't hear it in the argument, the oral argument, but much has been made about the fact that there's a provision in Rule 3 that allows the applicant a 10-day period to file a request for a contested case hearing in a very limited circumstance. And that very limited circumstance is clearly defined. It says, if the board votes to issue the permit with conditions, which implies that you've heard the recommendation of staff, you've heard the oral comments, and you decide at that hearing to change the permit recommendation, to add conditions, that provision gives us, the applicant may reject the permit by filing a request for contested case hearing within 10 days after receiving notice of the board action. So the point there is that in the event the applicant learns at this hearing that something different will happen than what was published and noticed, then the applicant has a 10-day period to request a hearing on that permit application. There is no authorization in the rules, nor is there implied in the rules, any authorization for filing a request for a contested case hearing at any time after the formal hearing that is noticed and published, and basically provides the opportunity to hear these protests. Now, one of the accurate things, and one of the only accurate things in the response to our motion to deem these not timely filed, was the statement by these proposed protestants that there has to be a deadline. There has to be a deadline. More importantly, that deadline is jurisdictional. The brief of the other side cites a TCEQ case where the protestant missed the deadline by 15 minutes and requested specifically authority, as Marissa mentioned, to file 15 minutes late, presumably with some type of good reason or whatever. The importance of that case is that they had to ask permission. They had to invoke the discretion of the board to obtain a 15-minute extension of the deadline for filing a protest. In this case, the earliest protest was filed 7 days after the decision. Much is made of the due process argument. I would suggest to you that the due process rights of all parties to the proceeding need to be considered, and the effect on the due process rights of the applicant of allowing an unlimited time after the decision, after the rules clearly provide for some finality, for opponents to file a request for a contested case hearing, basically puts my client to the expense, time, and effort of a contested case hearing that is not authorized by the rules. The bottom line here is that any reasonable person reading these rules would conclude that if I have an individual interest that could be adversely affected, I need to show up at this hearing and I need to so state that I have an individual interest that could be adversely affected. And I need to request a contested case hearing as authorized by the rules. What you heard in the way of an argument was an equitable argument. These folks are concerned, and therefore you should allow them to have a contested case hearing to express their concerns. Those concerns were expressed at the public hearing. The board had the benefit of the public's input before it made its decision. A contested case hearing simply means that we have expense and delay and uncertainty in a process that should be designed and should be intended to create certainty. So with that, we would ask that you deem these protests untimely filed and reject these requests for a contested case hearing that were not within the district's rules. Thank you.
Any questions? Any questions of me? I have one, the Open Meetings Act. You touched on a little bit, and both sides did.
Yes.
That we didn't, they're saying in the open meetings that we didn't notice the public correctly. That we should have put in there that you can contest your case. And I see it that we did the right thing in an open, everybody knew who came, what could happen at this meeting, that we were intending to look at this and take a vote for or against.
Without a doubt, this district complied completely with the open meetings requirements in its notice, both published and notice of the meeting itself. And clearly that, I think that the evidence of that is the attendance at the meeting. But for all practical purposes, that is what the act requires. Notice the public of your intended action and the date and time and place where they can address those concerns. That was clearly complied with.
All right. I've got some other questions of Marissa. Same question to you. You wrote here, on the other hand, if the board chooses to simply deny all hearing requests and refuses to hold a contested case hearing, the board has opened the district up to judicial appeal premised on the variety of due process, Open Meetings Act, and abuse of discretion. Help me out. What do you see there?
Sure. I think that the main point here is that, in fact, the notice and the rules are not clear. Let me back up a little. It is clear that an opportunity to request a hearing or an opportunity to protest the applications was presented on the date of the public hearing. What was not clear is that that was the last date, or that was the only opportunity. That notice was not made clear. The rules don't make that clear. They use the word may instead of must. And therefore, if a person who has read the rules, who's read the notice, submits their hearing request at a later date, because the notice didn't clearly provide them with the instruction that, hey, you either make your protest on this day or you forever lose your right to protect your property interest, they have a good case to present to a judge. And let me also be clear that this is not an equitable argument that these hearing requesters are making. They're not arguing, hey, you should grant our hearing request because it's the fair thing to do or it's the just thing to do. The argument is that we read the notice, we read the rules, we did what our understanding of what those rules required. And we have property rights. We intend to participate in any hearing to protect those property rights, and we followed what our reading of those rules was. And let me also emphasize that there's nothing jurisdictional about this. And in fact, that is quite apparent when you look at the TCQ case. If in fact a 5 o'clock deadline for submitting hearing requests was jurisdictional, then the TCQ wouldn't have had the discretion to grant a 15-minute extension of time. Jurisdictional means it's yes or no, black or white. You either have jurisdiction, you invoked it, or you didn't, and there's nothing you can do to fix it. The fact that TCEQ could grant a 15-minute extension of time to submit hearing requests, that means it wasn't jurisdictional. That means that TCEQ has wide discretion to accept hearing requests, just as this board has wide discretion to accept hearing requests under reasonable circumstances, under a fair reading of the rules and what the requirements are, and people's attempt to comply with those rules.
None of your clients, on that same night, we also had a hearing for Wembley Water Supply Corp., and none of your clients protested or contested that. Are they intending on contesting that now? As in, how many days does it just go on forever and they could decide tomorrow that maybe it's, I mean, that kind of confused me, that Wimberley Springs water wells are closer to some of your clients, I think. And that wasn't an issue with the groundwater being used. So I'm just trying to figure out.
My understanding is that they don't intend to protest in that case.
And did any of your clients at that meeting ask for a contested case, the first meeting we had?
I believe somebody else who was actually there could better answer that question. Did you guys hear that?
I'm sorry.
Anyone who was at the public hearing, did they actually state that they?
Asked for a contested case.
Did they use the words, "I request a contested case"? I would imagine that the record for the meeting will show whether they truly did or not.
And
There were a number of people, over 20-some-odd people, who appeared with concerns and complaints about the case. There were some that appeared to support a few. My personal judgment is the break was probably somewhere 80-20, 85-15%.
So it sounds like there were certainly.
But I'm
some
sure the
members-
record, which the board has, both a visual record and a audio record, will show what was actually said at the meeting. Thank you.
So it sounds like at least some of the members were clearly protesting that.
Right, I think at that same meeting
Right.
on the Wembley Springs or Wembley Water Supply Corp., people spoke on that too, not in favor of it.
Mhm.
Ma'am,
Yes.
I'm Mark Key, by the way. My question is, I understand where you're saying, oh, these rules are confusing, something, but the problem, well, that doesn't hold water with me, is the WVWA president was also the longest serving member of the Hayes Training Board and was probably responsible for writing a lot of the rules. And that's kind of the problem I see, that the man that wrote the rules should know how to interpret them, or was at least involved in writing rules. And also our Vice President David Baker, who is not here, has also been long, in fact, most of all the lead complaints have had long histories with the groundwater district.
And perhaps that's why their interpretation was that the drop-dead deadline was not the date of the public hearing. That's a fair interpretation of the rules, is that.
If I'm not sure, I ask, so normally I say, hey, this rule can be read two ways, which way are we going with this,
I think that's fair enough. I think that, many of us would ask, is this my only shot at